Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. We are your co-hosts, Rebecca Strauss and Sarah Willey, two employment lawyers who spend their days guiding employers through all of the challenges that workplaces offer.
Good morning, Rebecca.
Hi, Sarah. How are you?
Good. How are you doing?
I am good.
Excellent.
Really good. Yeah.
Excellent. It's been a busy week, hasn't it?
It sure has. Kind of reminds me of a year ago with constantly changing rules and everyone trying to.
That's exactly right.
Trying to sort it out. So I am so grateful to have this opportunity.
Right.
To sit down with you and talk about something not directly COVID related. Right. Some of what we're seeing is a fallout probably from the last year, but we're going to take a break from COVID safety related questions and talk about something way more fun. And our theme of the week this week is marijuana.
Excellent. I have been getting, over the last several weeks, I actually have been getting a lot of clients calling and asking, wanting information about what their options are with regard to testing for marijuana, what to do if an applicant or current employee test positive, etc. Are you seeing the same thing?
The exact same thing. And how did we come up with this topic for today? Just to remind everyone why we do this podcast in the first place. We saw each other in the hall and said, why am I getting a bunch of questions about
marijuana
substance policy, and specifically marijuana, and most specifically in my experiences, at least pre-hire, you've had more of a mix of pre-hire and post-hire questions. Mm-hmm. And we have a few theories about that. One has to be, it's just harder for employers to find employees right now. That's why I said it's not directly COVID related, but maybe a fallout from the pandemic.
Oh, definitely.
And we don't want to disqualify people that we don't necessarily have to disqualify. So employers, at least in my situations, are looking at why are we disqualifying people, right? For testing positive for marijuana pre-hire, and do we want to continue doing that? Or do we want to open up our pool a little bit? Right, and get some more people in the door.
Yeah, and it's interesting that the hiring market is so challenging right now for employers. And I think several months ago, I think that was true, particularly manufacturing.
Yeah. Mm-hmm.
And I have just seen that increase through really every industry. So the hiring market is a huge challenge, combined with, this is sort of a combination of two factors, I think, at the same time, combined with, of course, the increased use of marijuana as different states have legalized marijuana for medicinal purposes, recreational purposes, and both. So we have more people using marijuana. We have employers needing more warm bodies to come in, right, and perform work for them. So it's raising a lot of concerns about that pre-employment drug screen.
I'm going to add one more. It kind of goes along with what you just said. It's just slightly different. The laws in the states have been changing so much, right? So we have policies that were set in place when any type of marijuana was unlawful, right? Mm-hmm. So it was easy for an employer to say, we're excluding anyone who tests positive for marijuana. But now that it is legal in many states for recreational use or any use, employers are starting to rethink that. Well, wait a second, right? We don't exclude people who drink on the weekends, right?
Definitely, right.
So why are we, now that it's legal, now that the law has changed, why are we excluding folks who test positive for marijuana? And not everyone's coming to the same conclusion on that, but it's really started some interesting conversations with our clients.
For sure. I think before we dive into that, it makes sense to start with what is the law right now on marijuana? Don't you? Because I
well, we are lawyers.
Yes. Well, yeah.
So maybe one or two of folks listening might want to hear what we have to say
about that, right?
On that, because we love to talk about everything else, but we have lots of opinions on a lot of stuff. But yes, what is the law? So let's separate it between federal law and state law.
Definitely,
okay? Because there's two legal systems in America. So under federal law, that's easy, right, Sarah? Because there's only one federal law.
There is only one federal law, and sometimes people are surprised to hear that marijuana is actually still illegal under federal law. And of course, they're surprised to hear it because we don't hear much about our federal government, our federal law enforcement agencies enforcing that, right?
No.
And that is because largely our federal government has said we are not going to enforce it in states and areas where it is otherwise legal. Okay. But as a matter of law, under federal law, marijuana continues to be illegal. And of course, that can impact many employers if they have federal contracts, right? And if they have DOT drivers, etc.
Still relevant to many, many employers.
Right.
So federal law, and again, what makes this easy is there's one federal government. It's still illegal in every state of the union under federal law. But states, now that's where things get squirrely.
They get very complicated.
And we talk about this whenever we talk about any type of employment law. You got to look at the state, where you're at, and just pausing for a moment, not just where you're at, but where your employees are at. Now that you may have remote employees in other states where you have no facility, they're an employee of that state. So we talk about that when we talk about any employment law, but I've never seen laws vary as much state to state as I have with marijuana laws.
I think that's true. A close second might be paid leave laws.
Oh, you're just saying that.
One of my other favorite things to talk about. But,
one of your loves.
But yes, they vary incredibly, and of course they're changing by the minute.
By the minute.
And before we sat down today, I went back because I was just curious whether there are still really any states that don't offer marijuana legally either for medicinal or recreational purposes, right?
Are there any of those states left?
So by my count, I think there's about 10 states left that don't have either one, right? States in which marijuana isn't legal for medicinal purposes and also continues to be illegal for recreational use. So not a whole lot, only 10, and the other 40 are all over the place.
All over the place. And let's just break down a little bit what we mean by all over the place. It's not just as simple as saying, check a box, medical, yes or no. Check a box, recreational, yes or no. Let's take a state that allows for recreational, which would include medical as well, of course. All kinds of laws about what you can test for pre-employment, what you can exclude for if a positive test comes back, right? It's all over the place.
And whether you can fire an employee who tests positive and what you might have to show in order to do that. So yes, all over the place. And so you're very right. Employers need to understand the law of the state where they're in before they can really dive into what their options are in this space.
And at least, this really surprised me, at least some states require a notice in the job ad about whether marijuana would
Several
be considered.
States do.
Right?
Several states do.
So this isn't even something to start thinking about once you hire someone in another state. This you have to think about if you're going to advertise nationally. You have to start thinking about what the laws are in all the states.
Yes, several states require businesses to disclose that they are going to require pre-employment drug testing, which is it's like fair notice. Don't take the time in applying for this job if you know you're not gonna pass the test. So.
Which is only fair.
Yeah, really.
It's hard to argue with, but I bet a lot of our clients aren't aware of that. So our clients that are still do and will continue to screen for marijuana pre-hire, I bet a lot of employers whose home base is not in one of those states don't know they need to include those notices in their national advertisements.
Sure. So let's take pre-employment first.
Yes.
Okay. For employers who are thinking about this. And I agree with you. Pre-employment seems to be the starting place. They're starting to ask these questions first with regard to pre-employment drug testing. What do you see as their options?
Well, folks have a few options. Again, depending on the state law, there may be more or less. So we're just going to talk in general here.
Okay.
Again, PSA, check your state laws wherever your employees may be. But you could continue in what I would call the traditional model, which is you're going to you're going to pre-employment test for marijuana as well as any other prohibited substance.
Okay.
And any positive result will automatically disqualify the candidate. No questions asked, right? Don't pass go, don't collect $200.
Okay.
You're out of luck. Another approach I've seen is to continue the marijuana test in the panel that is tested for, but then either the employer doesn't care if it's a PEV, they just disregard the result for marijuana, or they have an individual discussion with that applicant to see if there's a reason, right? Maybe a medical reason, for instance, maybe something that sounds to the employer like it's reasonable. I've seen that approach. And then the approach all the way to the other side, of course, is just not to test for marijuana at all. And then some employers, of course, don't test for any drugs at all. So you could do no drug tests, or you could do a panel and just leave marijuana off the panel, and that way you just don't know. Because if you're not going to make a decision on a positive result anyway, what's the point of getting a result in the first place?
Right. So as employers are thinking through those options, right, and deciding what they want to do, where should they start? Where's the starting place for them?
Having had a few conversations with clients before, where we always start is, why did you have your original policy in the first place? And then does it still make sense?
Yeah.
And I think that depending on the employer's motivation for a change, they may start with another question. But I think for lots of folks who are just thinking about this now, maybe as a result of hearing this, that's a great place to start.
That's an excellent point.
Not every employer does drug tests. Lots of them never did and may never. But if you're listening to this, you're probably working for an employer that has in some way. So why? Why were you doing it? And now, assuming you're in a state, or your employee is in a state where recreational marijuana is legal, does it still make sense? So why? So that's the question. But now, what is the answer?
Right. And that, of course, will depend.
Why did employers start doing pre-employment drug tests? Several reasons, right? I'll start with the easy one. And you have other ideas. First of all, some employers may not have a choice, depending on their workers' comp carrier, right? Sometimes insurance companies kind of make the rules of the game. And so whatever we're discussing here, and before making any changes, you're going to want to check with your workers' comp carrier, right? Because you don't want to exclude coverage.
And you might not have a choice for some positions, too. So DOT drivers are an example of individuals that are required to pass drug tests in that regard. And
what are some other reasons?
Yeah, I mean, the biggest one, I think, is safety. There's this idea that if we allow an employee that we know is using drugs to come and work in our workplace, there's a concern that they will be under the influence of drugs when they come to work. And that obviously raises safety concerns. So in the past, I think employers have thought, well, an easy way to eliminate that risk is just not to allow drug users ever in our workplace, right? And then we don't have that safety concern. That's becoming more challenging as more and more people are using marijuana.
Yes, definitely more challenging. I think there's also the perception that people who use prohibited substances may be less reliable, attendance-wise.
Sure.
Right? Whether that's borne out by the evidence or not, I am not completely sure, but there is certainly that perception that there is a risk there of hiring an unreliable employee. Related to reliability, you have theft concerns, right? Because addicts have to pay for their addictions, right? Marijuana is not expensive as other prohibited substances, but I think some employers are always concerned about that, too.
And that may have been why they created the policy in the first place, right? Which is what we're asking. And then some employers, I think, just from a point of morality, take a position that they don't support the use of drugs and they don't want to employ anybody who is using prohibited substances. And some employers will continue to say marijuana is still illegal under federal law, and I'm not okay with anybody working in my company if they use it. So I agree with you. I think that's, generally speaking, why employers might have created that practice in the first place, created that policy in the first place. And then I think you're right. It makes all the sense in the world to take a time out and say, do those things still apply now?
Right. And by the way, and I said earlier in answering your question, now that recreational marijuana is legal in the states where it is, but really even in the other states, folks may want to take a step back and decide whether those reasons still make sense for their organizations, especially in light of the trouble hiring people right now. Maybe folks are more willing to take a chance, hiring someone that may have poor attendance, for instance, but it's better than nothing, right? And we're willing to take the chance now. Whereas when we had, 100 employees for every position, we had to exclude people based on something, right? We might as well exclude people based on that.
Yeah, the market drives
now where we have one employee for every 10 open positions, changes the calculation a little bit, right?
Yeah, definitely. One question that I've gotten several times is something like this. So if we implemented this practice, the pre-hire drug screening, and we did it maybe for safety reasons, right? Should we be concerned then from a liability standpoint? Can somebody say that we were negligent by not doing our due diligence when we hired a person, or even worse, when we knew they tested positive for marijuana, yet decided to hire them anyway? Is that going to come back to haunt that employer? What are your thoughts on that?
Okay, so that's a tough question. I've got two thoughts, and I'd love to hear yours too.
That's what this is for.
First thought is, when I hear risk, I think insurance, right? That's just where my head goes. That's how businesses, there's risks in lots of things businesses do. We can't eliminate it. How do we go forward doing what we need to do in spite of risk? And I think, insurance. So again, I would touch base with your workers' comp insurance or even general commercial liability carrier, right? To ask them, are they going to deny coverage if you no longer exclude employees based on a positive marijuana test? Because if not, right, you're covered from a financial standpoint. So there's no negative financial outcome from a risk you might be taking on. Is there a risk of just a successful claim, though? I thought about that, and I don't see it. I'm not aware of a case where someone said you should have tested for marijuana and you didn't.
A negligent hire type case is what it would be,
if
right?
Only you had tested this person for marijuana, you would have known they were a user, and then they would not have gotten into this accident, right, that caused injury to my loved one.
Right.
It's such a stretch to me.
Or even you knew this person uses marijuana. Again, taking the example of an employer that does the test, knows an applicant tests positive, but decides to hire them anyway, right?
Right.
I still think that's a stretch to say that employer is on notice that that person is likely to come in and cause a workplace accident.
I think so, too. I think we would need a lot more evidence, right?
Yeah.
We need some objective evidence that people who ever tested positive for marijuana actually caused risk of harm to others.
In the workplace, right.
And why is it so hard, Sarah? Because these tests for marijuana, right, they don't tell you when the person used or if they're currently under the influence, right? So even if someone tests positive at pre-hire, doesn't mean they're a current user, doesn't mean they're using at work or are likely to. Right? It only tells us so much.
Yeah, it'll tell, the tests are getting better. They give levels now.
Okay, well, that's an improvement.
It is a bit of an improvement, and not all tests, but some tests can give you a general level of where somebody is. Unfortunately, though, as I understand it, everybody metabolizes marijuana differently. Okay? And it's metabolized much more slowly than alcohol. So whereas with alcohol, we can take a measure of somebody's blood alcohol level and have a pretty good idea of how much they've had to drink in the last several hours and whether they're under the influence of alcohol or not. In fact, we can get an actual number and compare it to a law that says you're under the influence, right? That's
Fancy
wonderful.
That. Wouldn't we love
Fancy
to have that
yes.
with marijuana?
Unfortunately, with marijuana, it's metabolized much more slowly than alcohol.
Okay.
And so what one level means in one person doesn't mean the same in another. And in particular, somebody who regularly uses marijuana could have a higher level, yet not be under the influence. Whereas somebody who almost never uses it, or maybe used it for the first time, could have a much lower level, yet still be under the influence. Okay, so to your point, the tests almost give us nothing more than, yes, this person has marijuana in their system and may have used it over the last several days, and that's all we know.
That's all we know. That is a real problem. We have no idea if the person smoked it at work, before work, even the night before work. It truly could have been the weekend before, right? And by the time they get to work, there's probably not a risk factor, right, in terms of injury.
Right. So if we take that concept and also talk, so what I had just asked is, do we have to worry about risk or liability if we hire somebody that we know uses alcohol, right?
Marijuana.
Marijuana, right? If somebody uses marijuana. And we also then have this idea that we don't know based on a test alone whether somebody at work was actually under the influence of marijuana.
Right.
Okay. What I would say is, excluding any applicant who tests positive is a very overbroad way to address what could be a safety concern. Wouldn't you agree with that?
I think there's better ways.
There's better ways, right?
It's like hitting a needle with a sledgehammer. Right?
Right, exactly.
It works.
It's effective.
But is it the best way?
It's effective.
Is it the best way?
It's effective, but I think really what employers need to be doing now is thinking about whether there's a more refined way to be addressing those potential workplace safety concerns, other than saying we just aren't going to hire anybody who's used marijuana in the last month.
Right.
And what most employers are trying to get their arms around then is, what does that mean? How do I then, in my workplace, do a better job of recognizing whether people are actually under the influence when they're at work?
Right. And so this brings us very neatly from the pre-hired category, right?
Sure, right.
So now you have some folks who may or may not be under the influence at work. And this is a question I've gotten many times over the past few years. And the answer is, sadly, as we just talked about, a test alone is not going to save the day here. It would be great if we could just
Wouldn't that be wonderful?
Just test them, right?
By the way,
positive test means they're under the influence. Negative test means they're not. And there's no more analysis that needs to be done.
And if anyone in our audience is looking for a big idea, that would be the one, right? Come up with the test that can tell somebody, can reliably say whether or not that person is actually under the influence, particularly of marijuana.
Right.
That is a multi-million-dollar idea. So you're all
sure
welcome.
There's someone on that.
You're all
and if you need an investor,
yes, right.
Off the Clock podcast.
Yes,
let us know.
right, exactly.
Yes, I'm sure there are lots of research scientists working on that right away, because with the explosion of legalized marijuana across 40 states at least, right?
Yeah.
This is on everyone's mind across the country.
But for the time being, what's an employer supposed to do?
So the magic phrase that our clients are using, that we use, is reasonable suspicion, right? I'm sure you've used that in your policies and in conversations, right?
Yeah.
This is a question I get. What the heck does that mean in real life?
Right.
What does that mean?
And I think, again, and I know we've said this before, but employers just haven't spent a lot of time thinking about reasonable suspicion, because they've had the luxury of just, if somebody tests positive, they've found that to be a violation of the test alone, or of the policy alone, right?
And at pre-hire too. So they're much less likely to have people in the workplace that are, unless they started using after they came to work for you. Yeah. Possible, less likely.
So from a practical standpoint, I would encourage our HR folks in our audience to begin thinking about, how are we going to implement a reasonable suspicion approach down the road, because I really think that's coming. We're no longer going to fire or not hire somebody automatically just because they've tested positive for marijuana. We're going to need something else.
Yes, yes. Let me ask you this. Reasonable suspicion, you said that will be a basis for employment decisions, right? Termination decisions. What about whether you can send someone for a test? I've gotten that. But you need reasonable suspicion just to ask John Doe to go for a test. Or
and that can depend on state law.
Yep.
And so, good news, I'm not going to recite the law of all 50 states right now. I'm sure you do.
I can think of nothing more interesting.
Right. No. In Michigan, the answer is no. You can have a policy that requires testing for a lot of reasons. One of them might be simply post-accident. We see that in a lot of policies. A lot of workers' comp insurance policies require that. So you don't currently, in Michigan, have to have reasonable suspicion to send somebody for a test or to end their employment, but in other states you might. Where I think, though, employers are heading is some sort of reasonable suspicion protocol that includes a training. Yeah. Right? For whoever it is on the floor, supervisors, managers, to be able to identify whether or not an employee is likely under the influence of marijuana or another drug before they send them to testing.
And this is not a brand new concept, is it? Having protocols, training supervisors regarding reasonable suspicion of being under the influence.
It's not a brand new concept, particularly for those in our audience who have DOT drivers. They're very familiar with this concept.
Yes.
The DOT has very detailed regulations about what training is required for supervisors and what reasonable suspicion is, et cetera. It's just that not a lot of employers have applied that more broadly than DOT drivers.
And for folks that don't have DOT drivers, they're coming at this from scratch, right? Without any of that background at all. Yeah. But yes, there are standards, there is training, right, that you can provide, that we can provide, right, that will help supervisors get their head around this beyond their just preconceived notions about what a high person may appear like.
Sure, right, exactly. And be consistent, right?
Right.
I like to say somebody's ability to recognize whether an individual is under the influence of marijuana at work shouldn't depend on their college experiences, right? It should, or their high school experiences, right? It should be based on some sort of science, some sort of protocol, checklist, et cetera, that they're going through to help with that.
So let's talk about an idea I recently became aware of, I think you did too, about how science and technology can help with this. I find this fascinating.
Okay.
There is at least one company, and probably more, who offer an app that do responsiveness testing. So get this, it's on cell phones, or you could set up, if your employees don't have cell phones, like in a manufacturing facility, for instance, you can set up stations around the floor, right? And it measures a baseline for each employee as the response time to certain tasks on the app or the computer, right? Okay. Recognizing shapes. None of these questions are hard, right? It's just what color is this, what shape is, those sorts of things.
Right.
And it measures the baseline response time, which could be very different, right? My response time might take me 2 seconds, right? To answer the questions, it might take you 2 minutes, completely unimpaired. And that's fine. That's your base. And then the employer can ask employees to retake the test at various times during their shift. It can be maybe just right after coming after a break. It can be maybe 2 times a day, 3 times a day, really whatever the employer wants.
They'll have to pay them for that time, by the way, right?
They will absolutely have to pay them for that time. So we don't want to do it too much, right? You don't want to stop the line too many times. But yes, that is definitely paid time. And then if the response time varies too far from that employee's baseline response time, an automatic notification is sent to whomever the employer designates, a safety coordinator, HR, whomever it is. And then that person can go approach the employee and check it out. I don't think it necessarily means the person is under the influence, by the way. there could be other reasons, right? They could be up all night with a baby. They could be pulling a second shift and just be drowsy. They could be distracted while they were taking the test, maybe, and be able to explain that to you.
Okay.
But I found that to be a fascinating way technology can help us and our supervisors
Get our arms around it. Wow.
get our arms around what might be reasonable suspicion of being under the influence.
And it's a great example of really the degree with which employers are struggling with this concept,
Yes.
right? The idea that
Someone saw a need and filled it.
yes, exactly.
Yes. Yes.
And so when you say you would go and check it out, right? If somebody gets the notification, I presume what that would mean, again, is some sort of reasonable suspicion analysis, right? They would want to have in place steps to follow to identify, was it because you were up all night with the newborn? Was it because you were distracted with something else? Or do you appear to be under the influence of drugs?
Right. And let me say, even though we're talking about drug use in this episode, if you are drowsy or your response time is low for a reason other than drugs, being up all night with a newborn, something you and I could relate to back when we had newborns, that still could present a safety issue, right?
Goodness,
So you would still want to know that, even if it's not a reasonable suspicion of drug use.
And I would hope each employer would get to sort of create the threshold for what's an issue and what's not.
Yes,
I mean,
absolutely.
there were several years that I would not have passed that test, Rebecca. And I don't mean days, I mean years on end. But that's neither here nor there.
I'm with you. Luckily, we're not operating heavy machineries. Miller Johnson could deal with that risk. Our malpractice carrier,
Yes,
I'm sure,
I was
on
not
notice.
driving a forklift.
But if you're driving a forklift, operating heavy machinery where digits can get caught up in it, etc.,
Then
that
that's
may
an
be
issue.
something you want to know,
Okay.
right? If someone's not performing at their best.
One other thing I think we should talk about for just a few minutes before we sign off. This has been so much fun. What about reasonable accommodations? Right? Do we,
Yes. Oh, is that complicated?
Right.
Okay.
as marijuana has become more available, it's also become increasingly used to treat medical conditions.
Yep.
For legitimate reasons.
Absolutely. I've heard
Okay.
lots of them from clients.
Absolutely.
Long-term pain, trouble sleeping,
Yes.
right? All sorts of things, yeah.
Appetite. People on chemo, taking chemo can use it to stimulate appetite, things like that. So
Yep.
there are legitimate medical reasons for people to use marijuana. Okay. And so what do we do as employers when we have somebody test positive for marijuana, whether it's pre-employment or whether it's during employment, post-accident, or for some other reason, and they say, but I'm using it for these legitimate medical issues?
Okay, so that's to me, that's two really great questions. One directly related to marijuana, but one, it's more of a general ADA, reasonable accommodation issue. I'm just going to do a little PSA on that now because I see this issue come up so much. What if that is exactly what the employee says, but then does not also say, and I would like an accommodation under the ADA to be able to continue using marijuana because of my qualifying disability?
Yeah.
What if that whole last part is gone and all they do is tell you, right, that they're using it because
marijuana.
of
Right.
fill in the blank
Is that a
medical
request?
issue?
Sure.
My opinion, and yours probably too, is yes, that would trigger the reasonable accommodation process. We could argue on the back end whether that was sufficient, maybe not. But best practice would be to sit down and start the reasonable accommodation process at that time.
Sure.
True?
Sure. Yeah, exactly. And
So now it's the harder question and a fun question for us because it's an evolving area of the law, which is always fun. Not for our clients because we have to tell them it's changing right now. But for us, it's interesting. Can that be a reasonable accommodation? What do the courts have to say about that?
so, again, we got to separate federal and state law.
Ah, yes.
Okay, so remember where we started, which is marijuana is still illegal under federal law.
Okay, so did the federal court say engaging in an illegal
most,
activity?
yes,
can be
most
a
federal
reasonable
courts,
accommodation?
most federal courts have continued to say it wouldn't be a reasonable accommodation under federal law to allow an employee to violate federal law. Okay.
It sounds so reasonable when you say
even
it like
I can
that.
make that argument, right?
I get
it's
it.
a two-sentence brief. Okay.
Perfect. Okay. But are all cases filed in federal courts?
They are not, as you know. They can
that would have been
also,
easier.
yes, exactly. They can also be filed in state law or in state court under state law. And they're not going to be surprised to hear us say states are
They're all different?
They're not all different, but there have been states that have been more inclined to walk down that path. And it also depends, I should say, on the marijuana laws of that state.
Yes.
So some medicinal marijuana laws say you cannot discipline or discharge an employee for legitimately using medical marijuana. Some states even say you can't discipline or discharge an employee for using recreational marijuana unless you can show they were actually under the influence at work. Okay? So that is going to depend on the law of each state. From a practical standpoint, I completely agree with you, and that is if you have an employee come forward and say, I have a need to use marijuana and it's for these health issues, then you should engage in the reasonable accommodation process with them.
Yes.
And part of that analysis will be you probably reaching out to legal counsel to say, from a legal standpoint, do I have to make an exception to our drug and alcohol policy?
Yeah.
And if the answer is no, then it turns to what other accommodations could be available for that employee.
Yes. And that conversation, by the way, should always start with what state is the employee in?
Yeah.
And if the folks calling started with that information, that would be lovely. Because if we've learned nothing else from this conversation, and from, frankly, looking at the research we've done on marijuana laws in 50 states, all 50 states, we've done the research, they vary so widely.
Correct.
It's really almost impossible for us to give advice without knowing the state of where the employee is located.
Yeah, that's right. That's right. Yep.
Okay,
Yep.
now,
So-
we cannot finish up a podcast on prohibited substances and prohibited substance policies
What's coming?
without talking about policies.
Oh, right. Yes.
So we're not going to write the policy for you in this episode. It's just much too specific to each employer. But if there's one takeaway on the policy side of this, it's look at your policy. Have you thought about it since marijuana has become either legal in your state or at least more widely used in your state, or you're having trouble hiring and you're thinking about not applying the policy as you have in the past, and make sure the policy expresses what your company wants you to do. For instance, in Michigan, recreational marijuana is legal, and the statute actually explicitly says, but employers can still prohibit marijuana when it's in their policy.
Yeah.
Okay,
So if
when
they
it's
don't
in
say
their
it in the
policy.
then-
If you have an old policy, it probably doesn't even mention marijuana. It just says prohibited substances.
Yeah.
It doesn't make any distinction. My guess is if this is a 15, 20-year-old policy, it doesn't make any distinction between prohibited under state law versus federal law, and it probably doesn't mention the word marijuana.
And I know a lot of other states that have laws that say something along those lines and require testing if it is allowed in the employer's policy, and allows discipline and discharge, but only if it's in the policy. So this would be a great time, because HR folks have just a latitude of time right now.
Nothing to do as we're coming out of the pandemic.
To put
Zero
on their
questions about vaccinations and masks.
Right. Yeah, put it on their to-do list should be take a look at our drug and alcohol policy, and maybe that gets moved up to the top of the list if they are an organization that is thinking about changing its approach to testing for marijuana.
Make sure your policy is consistent with what you actually want to do. Make sure it's updated based on now that marijuana is actually not a prohibited substance in some areas, and make sure it is consistent with the local state law.
Perfect.
In any state where you have employees, not where you have facilities, where you have employees.
Excellent.
Right?
Well, this has been so fun.
It has.
Yeah.
Okay, well,
All right.
good to see you as always.
Next time. All right. Bye, Rebecca.
Bye.